A partition action is a court process by which a court divides real property interests amongst the owners when they can't agree on how to use or manage a property. A partition action simply is an action taken to divide real estate property fairly among its co-owners. Most people consider a partition action when they want to sell their interest in a property, but the other owners don't want to sell, or they don't want to buy the other guy out for a fair price. This is typical of siblings who have inherited a property from their parents. A partition action is filed in the courts via a petition for partition action. Any partial owner of the property has the right to file for partition. Typically, the partial owner will work with an experienced probate lawyer to petition and file the action. We recommend exploring mediation either prior to or in conjunction with filing a partition action. Often, other partial owners will reconsider their position after discussing options and learning the pros, cons, and significant costs of a partition action. For example, a partition action is handled through the courts, which results in court costs and attorney's fees, not to mention delays, which all can be avoided through an early mediation. That means, in almost all cases, the amount of money available for all the owners after a partition action will be less than the full value of the real estate property in dispute. Mediation can help mitigate these costs, likely leaving everyone with more rather than less. There are upsides and downsides to a partition action. The primary upside is that a partition action breaks a stalemate between disagreeable owners. The primary downside is the cost. A partition action is the best option when co-owners cannot agree to property sale terms through mediation or negotiated settlement. And also, with a partition action, there is some chance of reimbursed costs associated through renovations. And lastly, with a partition action, there is potential ability to recoup your attorney's fees and costs. A partition action involves court costs and legal fees, and a partition action takes time. And frequently, if a property is sold at a forced sale through a partition action, you'll get less money in that sale than you would if you just sold it out in the open market. Attorney's fees can vary greatly, depending on the complexity of the litigation involved. Attorney's fees can range from $20,000 to over $100,000 per party. It's for this reason that we highly recommend mediation or negotiated settlement to avoid litigation and costly court processes when that's an option. While partition action forms are available online, we highly recommend speaking with an experienced probate litigation attorney. At RMO Lawyers, we protect people like you every day, and the consultation is always free. Once filed with the courts, a partition action cannot be stopped by a party who does not wish to sell the property unless the parties can resolve the dispute by settling. The county court will typically force a sale of the property, then divide the proceeds between the co-owners. Even if one of the co-owners currently lives in the property, the partition action will typically force the sale of the property. The easiest way to avoid a partition action is to not take title to property with another person. And if you're planning on leaving property to your children and you know they don't get along, then require the sale of the property and have the proceeds distributed to your children instead of the property itself. The key here is to be honest with yourself about those who will receive your property. We have seen several instances of defending a partition action, the most significant of which can be adverse possession or statute of limitations defenses. You should consult counsel who can examine what defenses you may have available to you. We recommend finding an experienced partition action attorney familiar with the county probate court in the county where the real estate is located. For example, if the co-owner lives in Miami and the real estate is located in Los Angeles, we recommend working with a probate lawyer in Los Angeles. A Los Angeles probate lawyer will generally be more familiar with the Los Angeles Superior Court Probate Division versus an out-of-state attorney. At RMO Lawyers, we protect and work with people like you every day. Contact us anytime for a free consult. Email us at hello@rmolawyers.com. Thanks for watching.